Hi YouTube, my name is Christopher Lachey of CW Lachey Law. I'm an attorney here in North Carolina, and what you're about to watch is a presentation done at a town hall on Second Amendment rights in North Carolina, as well as certain federal laws. This is the first of several talks where I go into detail about owning a firearm, dealing with police, dealing without a license, and theft and negligent injury with a firearm. All right, so my name is Christopher Lachey. I'm a North Carolina attorney. I practice all across North Carolina. I spend a lot of time here in Mint Hill. Most of my time is spent in Charlotte, and I do criminal defense almost exclusively at this point. People, assault with a deadly weapon, assault and battery, assault on a female. A lot of fighting goes on with my clients, and I have to defend them. Sometimes that deals with firearms. Sometimes they get charged with just having a firearm. Okay, North Carolina has what's called open carry. If you're 21 years old or 18 years of age or older, you can open carry your pistol in North Carolina. Put it on your hip, walk around. And that's fine, everyone knows that. Some people choose to conceal it. You have to get a special license, your CCW permit. There's a background check, 120-day waiting period depending on the county. Everyone knows that. But there's a problem that's going on in Charlotte that has been an issue for probably the last 10 years, and it's getting worse. It is what I would refer to as a chilling effect on the community, the gun-owning community. If you were to take a gun, put it on your hip, and walk in downtown Charlotte, I guarantee you will not get but a few blocks before you're stopped by an officer. You're going to be questioned. Now, I'll get to what happens when you're stopped by an officer, but they're going to ask you, what do you think you're doing? You're just carrying your gun. It's just on you. Perhaps you have it for self-defense. That's what a lot of people do. Perhaps you have it for work and you're going from one location to another. Perhaps you're a security guard, but you're not in uniform, but you have your firearm on. They're going to ask you, and they might detain you for a while to find out what's going on. Some people will be charged with what's called going armed to the terror of the public. This is an old law. I was surprised how old this is. It goes all the way back to 1843 in a case called State v. Huntley. I'll skip the facts for State v. Huntley, but it was a man wielding a firearm in what was seen to be a threatening manner. Based on the facts, I think it was a threatening manner. But they added this charge in the North Carolina Supreme Court called going armed to the terror of the public. And here are the elements. Let me see if anyone knows what these actually mean, because I certainly don't. There are two of them that elude me. The first one, anyone that arms himself or herself with an unusual and dangerous weapon. I'm not sure what that is. For the purpose of terrifying others, and goes about on public highways. Oh, that one's clear. Okay, public, so I can do this on my land. I can't do it in the street. I can't do it on the sidewalk. In a manner to cause terror to the people. I'm not entirely sure what that means, but I think I might know what it is when I see it. Some people might see a person that is a Second Amendment protester. I think these people do a lot of harm in the gun community, because these are the people that will go into Chipotle with their AR-15 strapped to them, because they just love eating at Chipotle with their AR-15. That's just, they have lunch every day with their AR-15. All that's doing is making people uncomfortable. But perhaps you just have an open carry pistol and you just go to Chipotle on your lunch break. You're a trucker, and you're just going into Chipotle one time. I don't mean to name drop. Chipotle doesn't pay me or anything to give their name. But you go to Chipotle and someone sees that you have a firearm. If you're in Charlotte, your chances of being stopped by an officer or picked up in that Chipotle or being asked to leave have increased exponentially. So much so that even restaurants that don't serve alcohol will say, this is a no-gun zone. We've posted no firearms, you can't possibly bring it in here. A lot of that is a result of people doing what I just described, going into locations with the sole purpose of spooking people because they're wielding their firearms. I think Target actually had some recent events a few years ago, actually, with the same thing happening. People taking semi-automatic rifles, strapping them to their bodies, going into the store saying, well, this is my right to carry. Now Target has a ban on firearms. Might not have been posted outside, but now it's a policy to ban all those firearms. All right, I'm getting off topic. Here's the important thing. Let's talk about those elements. So arms himself or herself with an unusual and dangerous weapon. I'm just going to look at the language of the case and see what the state had to say about what an unusual and dangerous weapon is. It has been remarked that a double-barreled gun, he used a shotgun, or any other one cannot in this country come under the description of unusual weapons. Okay, so they acknowledge that a double-barreled shotgun, hunting rifle, goose gun, whatever, those are not unusual firearms. For there is scarcely a man in the community who does not own and occasionally use guns of some sort. Any hunters? Me too. But we do not feel the force of this criticism. That's the court saying, I know how you all think because that makes sense. We don't think that way. A gun is an unusual weapon wherewith to be armed and clad, full stop. A gun is an unusual weapon, not a morning star with balls of steel and spikes on the end. That might be an unusual weapon. Any gun is a dangerous and unusual weapon for the purpose of this. For the purpose of terrifying others. What is for the purpose of terrifying others? All that comes down to is, did you take it out in public and someone saw it and they're uncomfortable? That might be your objective standard. That might be a reasonable, objective person saying, hey, you make my son uncomfortable. You have now gone out with the intent to terrorize the public. It can be that vague. We've already established goes about public highways, private land is fine. Public highways, not fine. In a manner to cause terror to the people. So if the element 2 is the intent, that you intended to do this, you wouldn't have gone to Chipotle with your firearm unless you intended to scare people. Well, in a manner to cause terror to the people, you're just sitting down having a meal with a gun on your hip. How are you're not wielding that, how are you using that to scare people? Well, Charlotte Chief of Police seems to think that open carrying in Charlotte is enough to be charged with going armed to the terror of the people, because it's unreasonable for him to think that someone would carry a firearm anywhere in Charlotte. Because as we all know, Charlotte's the safest place to be nowadays. I will say this, I said it has a chilling effect. Laws like this, you see all over the place. Charlotte is no exception, of course, but even parks. Certain places in North Carolina are monitored by local ordinances. If a park has a recreational facility, meaning they have basketball or baseball facilities available to kids, you can't have a firearm there. Which means that if you're out walking at night, I know some parks close at night, at dusk or sunset. Some parks would allow people to have a late night stroll. Is it safe to go for a late night stroll knowing that if you go and an officer stops you, you would be charged with going armed to the terror of the public? Oh, but wait, well, I'll just leave my gun at home because all the bad guys aren't going to be here because they're not allowed to have guns in the park. And all it does is stop you from carrying your firearm. I say that this was in 1843 because this instance of a law that actually deters people from carrying firearms came 18 years before North Carolina seceded from the Union. 18 years before we had the biggest conflict, before we ramped up to the biggest conflict in the United States, before brothers were shooting at brothers on their own land, towns were being invaded, we had a law that was trying to disarm the populace. I will say this one last thing because it's slightly entertaining to me, and then I'll move on to the next topic. About gun being an unusual weapon. It says here that no man amongst us carries it about with him as one of his everyday accoutrements, as part of his dress, and never, we trust, will the day come when any deadly weapon will be worn or wielded in our peace-loving and law-abiding state as an appendage of manly equipment. I'm not saying I'm the manliest person, but I carry this with me everywhere. I'm sure some of you do too. Thank you for watching. If you enjoyed this video and found it informative, like and subscribe. Go ahead and follow me on Twitter. You can also get my contact information in the description below. My firm is also on Facebook. There are many more video talks to come in the future, so stay tuned.